My name is Ebert. Most of the people read about me and know my case, a small bit of it. As a victim for over 17 years from the judiciary and legal professional and institution. Thanks to the judiciary, I believe I am registered at the Guinness Book, because as a desperate move, the only one in these countries that have got a court order that is not allowed to use public toilet and coffee house, I believe it's me. At the same order, it is an order made that despite the law of the country, no person in this country, especially the Her Majesty's servant, has to comply with the law of Freedom of Information or Data Protection Act. And the third point in this order is that any solicitor who is only trying to speak to me will speedily be transferred to prison without even trial. So I think this is an order which has been made by as desperation, and it is a mark on what's going on in this country. I would like to, I'm here to assist, and for myself, not for, and for everybody, because any person here who will succeed with anything, it is for all of us. The judiciary there is no, since the last 25 years, there is no independent judiciary in this country, there is no independent police in this country, and there is no solicitor who is not corrupt in this country. This is evidential. I want to highlight what happened in the last 25 years, which is important. I'm only highlighting the points. If anybody wants to know details, they are here. Now, what I have said this minute has been affirmed and established the last week. Number one, it has been established in the case of the Mohammed, or what's his name, Byron, the guy, everybody knows this picture. We can see that the judiciary has changed their decision and their judgment on instruction of one of the solicitors without informing the other side. It came to the public and there was a whole cry. And this has been published the last week, and then they changed it and came back with the full. So it's a right, clear proof that this matter has been an example, but because of Liberty, who has intervened here, the matter came to the public and has been changed, and the truth came in the full judgment. But the interesting point in this, to show how and why we are not independent, because the Home Secretary, Alan Johnson, attacked judges. He had the encouragement to attack the judges because he are used to, and it's already common sense, that the control on the judgment, on judges and the judiciary is controlled by the government. And how dare somebody is going to accuse against that? So this is one example. Second example, it's appeared on the 4th of March 2010. It is clear-cut that Zimbabwe has been upgraded at a time that the UK judiciary has been downgraded. Because I'm only writing the title here. South Africa court come to the aid of white Zimbabwe farmer. So in other words, the Zimbabwe citizen have got at least a court where they can go redress themselves. We haven't got a court, because wherever we go, what we go, refuse, dismiss, denied, with all kinds of stories. So we have got clear-cut what's going on here. The main problem which happened in this country happened in 1999. And this is under the motto civil proceedings, CPR, which is fundamentally flawed from A to Z. But I will only highlight 2 points. The issue is here, part 1, yes, overriding objective. This overriding objective applies only to solicitors or judges who haven't got any response to the point, but it doesn't apply to the victims. They can't use it. The other important issue which has been created through DCPR, a fundamental security which the public had. In the minute they lost, for whatever reason, rightly or wrongly, a court case, the costs have been awarded, but before 1999, the cost has been awarded subject to taxation. This taxation problem was a big problem for the judiciary and the solicitors, because the taxation requested the solicitor to disclose all the evidence, how they came to the costs. And those evidence has been concealed at the time from the decision was made in court. So they came and they just overturned it. There is no taxation anymore. The judge can be the judge and the taxation master and everything. He gets an invoice instead of £2,000, £25,000. It's a nice invoice, and he's a gentleman, and he's taking the 25 and reduces to 20, and this is an order and liquidated and finished. That's the end of the day. It is contrary to the rule of the solicitors, because the rule of the solicitor says clearly that there is no such a thing that a solicitor bill is a valid bill and definitely not liquidated until it is taxed. And that's what they avoided here.